Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. And this is the second video in our Form 22EF video series. And I am again joined by...
My name's Travis Davis. I'm with Coldwell Banker Tomlinson. I'm the branch manager out of Kennewick.
Thank you for being here.
Absolutely.
So in the first video, we talked about how important it is that you ask your buyer as you're writing your Form 20, as you're writing a purchase and sale agreement, buyer, where are you getting those down payment funds? Where are you getting the money to pay your closing costs? And the answer the buyer gives you will tell you whether those funds are contingent or non-contingent funds. And the definition that you've got to have seared in your brain for the difference between contingent and non-contingent funds, so that when your buyer tells you where they're getting their money from, you will instantly know contingent or non-contingent, because that determines your next step forward in writing that purchase and sale agreement. So I'm going to give you the layperson's definition of non-contingent funds, and I'm pulling that definition from the form, but I'm not going to quote the language on the form. You should read the language on the form. You should read the definition of non-contingent funds from Form 22EF. But essentially, if you remember this, you'll have a handy reference tool in your brain for what non-contingent funds include. If the money is not in a United States financial institution, I always want to say a U.S. bank, but it doesn't have to be a U.S. bank, it just has to be a bank in the United States. So a United States financial institution, any bank, in an account, and the account is in the buyer's name, those are non-contingent funds. You don't have to disclose where those funds are. Now hold that in your brain for a minute, because we're going to come back to that, because you still should provide the seller information about those funds. But if they are non-contingent funds, then you're not required to disclose buyer's reliance on those funds based on Form 21 Paragraph A. All you're required to disclose is buyer's reliance on contingent funds. So again, before we go to the definition of contingent funds, the definition of non-contingent funds, money in a bank account in the United States, in an account in the buyer's name. Non-contingent funds. So if that's the definition of non-contingent funds, Travis, give us an easy layperson definition of contingent funds.
Well, contingent funds are funds the buyer does not currently have available on their possession right now. So I mean, they can't show up with their suitcase of cash and go, here, I've got the money right now. It's coming from a different source, whether it's a stock sale or things like that have to be triggered, and I don't have that money readily available right now. Could be also the proceeds from a sale of an asset or anything like that, personal property.
Agreed. And in fact, I think the easiest way to describe contingent funds is to say, if they're not non-contingent funds, they're contingent funds. So if it's money that is anything other than in a bank account in the United States in the buyer's name, then they're contingent funds. So it could be anything, regardless how reliable it feels to the buyer. It might be money in the stock market. It could be money in a retirement account. It might be money that grandma has promised to give to, grandchild for the whole time they're a child growing up. They've always known, when I'm ready to buy a house, grandma says she's going to gift me, $20,000. And she's loaded, so it's not a problem. Those, though, aren't funds in a U.S. bank account in the buyer's name. They're in somebody else's name. They're in grandma's name. So they are necessarily contingent funds. So when you sit down with buyer and you ask that important question that Travis said in the first video, you absolutely must ask every buyer, where are your down payment funds? Unless they say, in a bank account in the United States in my name, then you know you're pulling out Form 22EF. Right?
Right, absolutely.
Okay. So we're gonna talk almost the rest of this series about contingent funds. But before we do that, Travis, let's talk about what you do with non-contingent funds. When the buyer says, I'm putting down, $20,000, and yeah, it's in a bank account right across the street, in an account in my name. I've been saving for years to be able to be in this position. As the buyer's broker, what do you do with that information, Travis, to sell this buyer's offer?
Well, what I would do in this, especially in this market, is I would put the proof of funds already with my offer. So I would say, hey, why not? Let's go ahead and put together the bank statement right now with this offer and include it. I mean, that would be simple. It may take that right out of the equation for that seller to look when they look at our offer. It's already satisfied.
Okay, so just to follow up on a pet peeve of mine.
Sure.
Because I know you don't do this, but I know a lot of people are confused about how you do this. I agree, you deliver it with the offer, but you never make it part of the
offer.
That's right. It's not part of buyer's offer.
See, this is the practicality of real estate versus the legal opinion. Just leave that out, but kind of include it. No, it's all good.
I know. Travis and I talk about how I have the benefit of living in the ivory tower, and that's true. I get to hand down edicts from the ivory tower, and the rest of you are in the business of actually putting transactions together and making deals happen, right?
True, very true.
And it can be a different perspective sometimes on how you handle things. Travis is absolutely right. Can't stress it enough. The proof of buyer's non-contingent funds should absolutely be given to the seller, along with probably they've got a pre-approval letter.
Absolutely.
Even better yet, an underwriting pre-approval letter.
Even better.
Yeah.
You want to add something even better?
What?
I don't know. Let's figure that out. I don't know what that would be, but that sounds pretty good. Sounds really good.
Well, I guess maybe a bank statement showing they've got 100% of the cash.
That would be,
right?
Yep, that'd be even better.
There you go.
Yeah.
But that's not necessary. When your offer goes over, your buyer's offer is one PDF, and then their financial support, their pre-approval, underwriting pre-approval letter, and a copy of their bank statement. Of course, you're going to redact their account number. You don't want their account number in your file for perpetuity or even in the seller's hands. They don't need that. You black out the account number. Travis, what do you do if a buyer says, no, I'm not giving my bank account statement. I only need $20,000 as the down payment for this property, and that's enough to pay my closing costs and my down payment. I don't want the seller to see that I've got $100,000 in the bank, because that makes it harder for me to negotiate the price I'm trying to negotiate. What do you do in that situation?
So in the case in which the buyer, their bank statement would show more funds necessary for the down payment they're putting down, if they have time, getting a letter from their financial institution stating that they have the amount of money necessary for the down payment would be awesome. It is very difficult to do, though, in a time crunch, of course, because you're writing up offers on late nights, and trying to get that letter can take a couple, 3 days. And as always, to kind of put a capstone on that, it's still the buyer's choice. The buyer still drives that bus. So if the buyer's that uncomfortable, then then you would insert the 22EF, check the evidence of non-contingent funds, which would give the buyer a time frame after the offer is accepted to supply that letter from the bank, and something like that.
Beautiful. I love that. That's perfect. And I love that you put it back in the buyer's lap, because of course that's always where every question gets answered by the buyer, right? And so broker's job is to raise these issues, because buyer broker, of course, your job is to present the offer especially in a super competitive seller market, present the offer in a way that's going to be most likely to get accepted when buyers competing against other buyers. And so if you can provide that bank statement showing that the buyer has sufficient cash to close the transaction, along with whatever contingent funds they might be relying on, the financing contingency and whatnot, great. But if for some reason buyer has that hesitation, if you can get that letter from the bank president or private banker showing the relationship between the banker and the consumer, and verifying that the consumer has sufficient funds to bring the down payment and the closing costs, fine. That letter's fine. The definition section, if you read the definition of evidence on Form 22EF, it says documents from a financial institution in the United States showing that the buyer has sufficient cash or cash equivalent in United States funds. So a letter from the private banker is fine. But Travis is exactly right. You're writing this offer on Sunday night at 10 o'clock, and you're presenting it Monday morning. Good luck finding the private banker to write you that letter, right?
Yeah, absolutely. And if you have that banker, let me know. I'd like to meet him or her.
So that takes us to Form 22EF. And when I used to teach this topic, I used to teach that Form 22EF should be in every single transaction because I contemplated that buyer brokers would be using the Form 22EF instead of bringing proof of funds. Travis is right that the better way to write an offer now is to provide that proof of funds along with buyer's offer rather than relying on the non-contingent paragraph of Form 22EF. But in this scenario, where, or if you're in the scenario where buyer says, I'm not comfortable providing a copy of my bank statement, then that's when you would mark the box, as Travis said. You'd mark the box, paragraph 2 on Form 22EF, evidence of non-contingent funds. And with that provision, seller then knows that buyer, within 3 days following mutual acceptance, buyer will provide seller the proof, the evidence from buyer's financial institution that buyer has U.S. funds in a U.S. bank account in buyer's name sufficient to close the transaction, along with whatever contingent source of funds are disclosed, financing, home sale, whatever it might be. Travis, let's finish up this video, because I think it's gone on long enough. But before we do that, is there anything else that is important for buyer brokers or even listing brokers to understand about the disclosure of non-contingent funds and the better way to write the transaction? Any closing thoughts you want to include?
There's just one more little thing that we see all the time. So when you're looking at evidence of the funds from the buyer, we see screenshots. We'll see screenshots from, they'll take a picture of their monitor, or they'll take a screenshot on their phone of their account. And as long as it's got the buyer's name, it's got the balance on there, and the financial institution, it's being used as an evidence of that, of documentation of that.
And that's the reality of today, right? Buyer may not have their bank statement at the ready, but they can always access a screenshot of their bank account, almost always at least. And when you look at the definition of evidence, it's documents from a financial institution, screenshot showing, like as Travis said, buyer's name, the date that the screenshot was taken, and the account balance. I think that's sufficient evidence of the buyer's non-contingent funds in their bank account. Okay, let's leave it here for today. There's more to come, I promise you, in a subsequent video. But for now, if you have questions on anything we've discussed so far or on any topic, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.